Okay. Okay, can everyone hear me?
Just have them nod, yeah.
Thumbs up.
Yeah.
People can hear? Okay. Does it need to be louder?
No.
Okay.
Horatio says no.
Okay, good. All right, so what I would like to do, first of all, I want to thank everyone for checking in and joining the Zoom meeting. I know this is not what we're used to, but it's what we have to do given the current social distancing rules. So we're going to be doing this every week. And I also had a call today with some other attorneys. And one other thing we're going to try to do is to set something up every Saturday where a number of attorneys get together and we all answer questions. And the idea there is that I know there's been concerns that some attorneys are saying one thing, some attorneys are saying another thing. And so the idea is if a large number of us who represent, 50, 60, 70% of the plaintiffs all get together and respond to the questions at the same time, then all of our clients can hear from us at the same time, and hopefully that will work to reduce the level of confusion. So what I'm going to do is talk very briefly about what happened this week, answer some of the questions that we received in writing, because what we did is we went through and we chose questions that were repetitive. That way we figured that would answer most people's questions, and then we'll take questions. So anyone who has questions, by all means, let us know. We'll open it up in about 10, 15 minutes, and you can just ask any questions you have. So I want to start off by talking about what happened. You may have seen the articles earlier this week. There were a number of them. The Chronicle did one, the Wall Street Journal, the New York Times. There were a number because the TCC filed a request to supplement the disclosure statements. And by now, you should have all received your disclosure statements. Those are going to be very voluminous. Sorry about that, but it's critical that everyone has access to all of the relevant documents. You absolutely do not have to read them if you don't want to, but we made sure that everyone had them so that you could review them. If you're only going to read one thing, I strongly recommend that you make it this. This is the Fire Victim Plan Treatment Summary. And it is only 12 pages. It's prepared by the bankruptcy court, and it lays out, according to the court's understanding of the plan, exactly what's going to happen. So again, if you're going to read one document, this should be it. You've all received it, and we're going to send out a letter on Monday that attaches this, and it also has a link to all of the pertinent documents so that you can look at any of them online if it's easier for you to do that. The whole point of this is we want to make sure that you have access to all of the information. So the first and foremost, I want to let everybody know that we do support this plan. We understand that there are concerns, and we're going to talk about what those concerns are. But in my view, there really is no question this is far and away the best available alternative. And that's mainly because the only other alternative, the only other plan that is there is the contingency plan that was approved by the court earlier this week. And that calls for PG&E to have what is in essence a trustee. It's called a transition officer appointed. That individual will essentially sell off all of PG&E's assets. That process will take, in all likelihood, 2 to 4 years. And when that's done, there will be an amount of money and everyone will be paid. It is almost impossible to imagine that they will get full value for that. So if the sale occurs, we're probably looking at payments of anywhere between 50 to 75 cents on the dollar for claims, and that will happen 2 to 4 years from now. Based on that, we think this proposed plan, which if it works out the way we think it will pay you 90 to 100 cents on the dollar within 6 to 12 months, is the preferred way to proceed. But obviously that's a decision that everyone has to make. Our job is to give you the information, make our recommendation. which we have. We recommend that you vote to approve the plan, and then it's up to you. So let's get to what the TCC was saying. And the TCC is a committee of 6 fire victims currently. Originally it was 9, 3 of them have resigned. 6 fire victims who work with an attorney, a law firm called Baker Hostetler, and they are not fire lawyers, they are bankruptcy attorneys, and they make recommendations. And so what the TCC wanted to do was to supplement the information that had been provided by the court. And we opposed that, along with a number of other groups. But the main reason for that is that the information that was contained in the letter, and the letter is right here, it will be on our server. It's also in the materials in the link that we sent out, so anyone can access it. And it's not that we have any problem with that information going out, it's that we did not want this letter to be sent to 77,000 people under the auspice of the court. Because when the court sends something, it is supposed to be neutral and absolutely factual, not argumentative. This letter was not argumentative. It was not neutral or scrupulously factual. It was very argumentative, and the goal was to delay the vote. The reason the TCC wanted to delay the vote is threefold. They had 3 issues that they wanted to raise. One is the stock price, one is the date of funding, and one is the reservation of rights agreement. And so I want to just address those very quickly. In terms of the stock price, there's no question that there's no guarantee. A stock can go up or down. That's something that we've known throughout. And because of the coronavirus and the devastating effect it's had on the market, all stocks have been down. Now, PG&E has rebounded quite a bit, and it's not down very much overall from the start of the pandemic. It's actually doing much better than many other stocks. But again, there's no question stocks can go up or down, and that was a risk that we took going into it. And we'll talk about why we did that in a moment, but I just want to address the specific issues addressed by the TCC. One was the stock price. They wanted the debtor, PG&E, to guarantee that it would be a minimum of $6.75 billion, but that if it went up, then the victims would receive the benefit. And as you might imagine, PG&E said, no, we're certainly not going to take all the risk and then give you the benefit. And the problem is that's not what the deal said. And when you're trying to renegotiate a deal, you need leverage. Here, the TCC did not have any. They were simply asking PG&E to rework the deal. PG&E said there's no way we're going to do that. And so while I think it would be great if PG&E agreed, because we'd already signed the deal and because we knew that there was a risk with this stock, and again, we'll talk about what's going to happen with the stock in a moment, we didn't think that had any chance of succeeding. And our other concern was it was a violation of our agreement because we agreed to something and now we're asking PG&E to change it. The second has to do with the date of the funding. You may have heard different dates, but the agreement that we signed with PG&E called the RSA, the Restructuring Support Agreement, which is bankruptcy talk for settlement agreement, requires PG&E to fund by August 29th. If they do not fund by August 29th, meaning if they do not pay the initial $5.4 billion and put in the stock, which again, we think will be valued at $6.75 billion or greater, but could be valued at less. If they don't do that by August 29th, that means that we have the right, as the plaintiffs, the sole right to walk away from the deal and convert it to the bankruptcy sale. That is the only other deal on the table, so that's what would happen. We have that absolute right. Now, it doesn't mean if they don't fund by August 29th and we don't exercise our right that this deal completely falls apart. We do have the option, and again, it's 100% our discretion to let it go into December. The only reason we would do that is if there was an issue with the way the stock was going to be calculated and we thought it would benefit you to wait to December. If that happens, then we'll all go back to our clients and we'll say, here's our recommendation, you make the decision. So that's the reason why the 2 different dates are out there. One is in December, one is August 29th. Again, August 29th is what is in the restructuring support agreement. and we have the right to terminate the deal in our sole discretion if we decide we want to, if they don't fund by August 29th. There are some other reasons why we think they will fund by August 29th. Most of those have to do with penalties that will be applied against them by both the governor and the CPUC if they don't. If they miss that and they go into September, then they have some significant penalties that they're going to have to deal with. So again, we think it's going to be August 29th. There is no guarantee, however. They could go past that. If they do, we have the right to terminate the deal. Then the final issue is the reservation of rights agreement. And this is this has to do with underwriting the restructuring of PG&E and the issuance of the new stock. As you know, what's going to happen here is that the current stock is going to disappear when PG&E reformulates. That's why when people say, well, if I look at the current stock value, what does it have to go to in order for me to receive this, or for us to receive the 6.75 billion? It's important to remember that all of that current equity, and equity is just a fancy word for stock, all of that is going to be diluted, and there is going to be a complete restructuring and a reissuing of all of the stock. And different people are going to get stock at different prices depending upon where they bought in. For example, if you were very prescient and you bought PG&E after the Kincaid fire when it was down to $2.83 a share, the lowest it's ever been, you're going to receive more than if you bought it at $18 a share, which is where it was about a year ago. So all of those things are going to be factored in, but what we know is where we, as the victims, are going to get our funding for the trust. It will be at 14.9 times the earnings, and the earnings are yearly earnings. And the reason that we thought that was a good deal then and think it's a good deal now is that the utility index average is 17.33. So by getting it at 14.9, we're getting about a 22% savings discount on what these stocks typically trade at. So that's what the TCC's concerns were. Our main issue was twofold. Number one, we don't want an officially endorsed letter from the court going out that is essentially, it's inaccurate in some respects, but it's also clearly advocating for a position that's not the correct function. If people want to send it out privately, they have the right to do that, and that's exactly what the judge told them. He said, I'm denying your motion, but if you want to send it out on your own as a solicitation and clearly marked as a solicitation, no problem, you can do that. I thought that was the correct ruling. We were very pleased with that. The other concern we have is that the TCC sending this, making this request violated the RSA, the restructuring support agreement that we signed with PG&E. The concern there is that if they wanted to, PG&E could then walk away from the deal. Now, obviously, we don't think they will, but my concern is, you know, look, we negotiated this deal, and it's now going out to the individual fire victims to vote on. If they're going to reject it, that's fine. They have that right. But the TCC, which is 6 people and their attorneys, should not be violating the deal, thereby allowing PG&E to do it unilaterally without giving the victims a chance to vote on it. So that was the other concern. Those things were addressed. So we're happy with how that worked out. What I'd like to do now is just kind of go through the most common questions we've had and talk a little bit about what the answer to those would be. So let's start with some questions about the value of the stock, because I know that's a big issue and people have asked about that a lot. And I want to say, you know, 2 things. Number one, I am not a professional stock analyst. I'm not a financial advisor. We certainly work with them, and we've received a lot of advice from them, but that is not my specialty. I'm an attorney, and so what we do is we take that expert information and we provide it to you so you can make the decisions. The reason that we believed at the time we signed this deal that it was a good deal, and the reason we still think it is today, is twofold. Number one, when you look at traditional utility company earnings and how stock is priced, versus what the amount of earnings are, that is the ratio from the earnings to the stock price, it's typically 17 and a third times, so 17.33. You multiply the earnings by 17.33, that's the number of stock. Here, we're getting it for 14.9. And that means that we're getting a 22% discount on what the average utility stock trades at. So that is very appealing. Now, what everyone anticipates is going to happen once PG&E comes out of bankruptcy is because of AB 1054, and that, as you remember, was the bill that was signed last year, became a law, and set up this $21 billion essentially revolving insurance fund for PG&E, Edison, and San Diego Gas and Electric. That it's not foolproof, but it essentially means that none of these utilities have to worry about going bankrupt in a future fire. What this revolving fund means is that once they get through their insurance, and each of them carry about $1 billion worth of insurance each year, if they have a fire that started by their equipment, as long as they can show that they filed a fire mitigation plan with the CPUC and substantially complied with it, then they have access to the $21 billion fund. And the whole purpose there was to make sure that the utilities didn't go completely bankrupt. The state of California looked at whether or not it wanted to take over PG&E and the other utilities. It decided it didn't. So at that point, it had to come up with a mechanism to ensure that they didn't go bankrupt. This is what they came up with. It has the stick. It requires PG&E and the other utilities to file this plan, get it approved by the CPUC, and substantially comply with it. But as long as they do, then they can't go bankrupt because they have access to this $21 billion fund. So from our perspective, everyone who was looking at it said the stock is going to go up once you get it based on that. And so what we're anticipating is going to happen is that the stock, which the trust is going to own, and that's another issue that we should talk about, it's a minimum of 20.9%. As of today, and I'm reading an email that I got from Tom Wagner, who is the head of Knighthead Capital. He's the main equity guy. And in writing, he said that as of today, that 20.9% is 22.4%. That amount is going to be calculated again based on that 14.9, and we think it's going to be substantially above 6.75 billion. Again, there's no guarantees, but just to give you an example, one of the things that a lot of people in the press and a lot on Facebook are pointing to is a letter and declaration that was filed with the court last week, where a financial advisor looked at it and said, if you calculate all this out, it would only be $4.85 billion. That's based on 20.9%. In order to achieve the 6.75, it would have to be 22.2%. So there were a couple of problems with his calculations, and to their credit, the TCC said, we don't think it's right. For, among other reasons, it's based upon Edison's current earnings, which were down because they were hit by the coronavirus and it went way down, rather than being based upon a yearly estimate. So there were some problems with it. But even if you take a worst case scenario, and even if you base it on exactly what this other financial advisor wrote, our share is 22.4. That means that even according to the way that he calculated it, we would have had over 6.75 billion. It works out to just under 6.8 billion. So again, while there is risk with stock, and while everyone certainly understands that, we believe it's going to be worth more than 6.75 at the time that it's funded. So that's one question. Now the next question is, why did the individual plaintiffs and their attorneys agree to accept stock as a form of payment when the insurance companies and the state and local, not the state, but the local, the county and city plaintiffs insisted on cash? As you remember, the local municipal, county, and city governments settled for $1 billion. The insurance companies settled for $11 billion. Now, there is an agreement that was cut between one of the insurance company holders and PG&E, where they're actually accepting stock. So technically, it's only $8 billion in cash to the insurance companies, but that's a side agreement and it's not in the RSA. The RSA itself says 11 billion cash, and people say, okay, if they got cash, why didn't we get all cash? And the answer for that is simple. The insurance companies accepted a reduction of over 40%. They actually had damages of 19.5 billion. And those aren't speculative damages. That's what they either paid out or they'd held in reserve based upon the claims that had been made and they would have to pay out. But instead of insisting on that 19.5 billion, they said, we'll take a substantial reduction if we can get paid cash now. So they accepted less than 60 cents on the dollar, works out to about 58, and they got cash. The governments, the local governments, accepted an even greater reduction. Their demand was over 3 billion. Their claims were probably worth somewhere between 1.5 and 2 billion, and yet they accepted 1 billion. So they are getting paid somewhere between 50 and 60 cents on the dollar, and that's why they got cash. We were not willing to do that. As you know, the initial negotiations with PG&E stalled out when they got to 8.4 billion. That was the most they were willing to pay, which would have been a little more than 60 cents on the dollar for us. And we said, absolutely not. The number that we believe it's going to take is 13.5, and that's what we're going to insist on. And so PG&E simply couldn't pay that in cash. They didn't have the cash. They didn't have the means to raise the cash. So what had to happen was we had to agree to accept stock. And by accepting stock, we were able to get to 90 to 100 cents on the dollar, as opposed to the roughly 50 cents in the dollar that the local governments got and the just under 60 cents in the dollar that Subboro got. Again, we think we got a good deal in terms of the stock. We think it's going to be worth more than 6.75, but we can't promise that. We absolutely can't. There is always a risk when you take stock, and so there's certainly a chance that it'll be worth less than 6.75. In terms of the next question, one of the things that was commonly asked has to do with the method of working up your individual claims and how the attorneys get paid, how the individuals get paid, how that whole process works. So let me go through that right now and talk a little bit about it. There's been a question of whether or not workups on everyone's individual claim are going forward. And the answer to that is yes. We are continuing the workups, and our goal is to have everything ready to submit as soon as the trustee and claims administrators open up the process. I spoke with both of them earlier this week, and they told me that as long as their funding continues, there was an issue about that, but it looks like we've got it resolved. As long as their funding continues, they will be ready on August 29th to begin payouts. And the great thing there is that while not everybody obviously is going to get paid right away, it does mean that we can start submitting our claims, and then as soon as claims are resolved, they will be paid. There's not going to be any artificial delay between the time that we resolve a claim and the amount of time people get paid. So the next question people ask is, once I submit my claim, what happens? And the answer to that is that it depends on the type of claim you have. Right now, it looks like there's going to be 3 different processes that are going to occur. There are a large number of claims that are fairly standard. That is, you're talking about a pretty typical home, you're talking about tree damages that would be anticipated, those kind of things. In terms of getting those paid, what the trustee and the claims administrator are going to do are look at our expert reports and then compare those to the averages for similar claims. If they're within a range, meaning that it appears that they're legitimate and they don't appear outside what they would expect to see for this type of home, then they're going to make an offer, and if we accept it, pay it immediately. If not, then we'll go to mediation to try and resolve it. If we can't, then it'll go to arbitration. But we think about 50% of the claims can be resolved that way. The second one is for those cases that are not typical. And that just means that, let's say that you lived in a custom home that was different in terms of type and construction than your neighbors, or somebody who lived off the grid and had a very unique home. Anything like that, a large business loss claim, anything that is outside the norm where we don't have anything to compare it to. So the only way that the trustee and claims administrators can make sure that it's a valid claim and not fraudulent, and it's not that anyone thinks anyone's going to do anything improper, it's just that they have a duty to make sure that they only pay valid claims. So what they're going to do is then look at the claims that we submit, look at the expert reports, and then they'll get their own experts to take a look and make sure that they're reasonable. If they are, they'll pay them. If there are significant disputes about whether or not a claim is reasonable, then we'll go to mediation, and if that's not successful, arbitration. That process is going to take a little bit longer. The third path is going to be much more limited, and it's only going to be for wrongful death and serious personal injury. Obviously those are the most tragic losses, and those will be dealt with separately. So there will be at least one, probably two claims administrators that will be assigned to do those, and that way they can get resolved at the same time. So it's not a situation because they're so large they have to go to the back of the line. They can go at the same time as some of the other claims are going forward. And if you have any question about how your claim is going to be calculated or anything like that, just talk to us, and we're happy to go through it with you. But we are doing those workups now. We're having our experts in the area. If for some reason you believe you need an expert and you haven't been contacted either by one of the attorneys or the expert to make sure that's going to happen, let us know and we'll make sure it gets done. So the next question is, how are attorneys paid? And I understand that because there was some talk about a class action and there's not a lot of understanding oftentimes about what happens here, there's an idea that attorneys get their fees up front as they do in a class action. And because of that, the attorneys don't have the same skin in the game, so to speak, as the individuals. And I want to assure you that's not the case. We do not get paid until you receive your recovery. So there's no X amount of attorney fees that goes to us and then you have to fight about your claim. The way that it works is that once you get paid, then we get a percentage of that and we recover our costs. But it's not like we get paid first and then you have to work out your own. It does not work that way. We only get paid, and that's not just for our fees, but also for the costs we've advanced until you get paid. Now, one question that comes up a lot, I think everybody understands you are not going to take stock. You're going to be given cash, check, but cash for your settlement. But people say, okay, am I going to get the full amount up front? In other words, let's say that I submit my claim, the trustee looks at it, checks all the boxes, says, yes, 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 this is reasonable. Okay, your claim settles for $500,000. Do you get the $500,000, all of it right then? We don't know for sure, but I strongly believe the answer to that is going to be no, and here's why. The trustee has a fiduciary duty to all 77,000 of the fire claimants here. Some people are going to receive a very small amount. There are those folks who evacuated, and certainly that's frightening, and they deserve to be fairly compensated. But obviously, if your only loss was evacuating, that's going to be very different than if you lost everything you owned, you were nearly killed, those kind of things. So, awards could range from, 5 to 10,000 for some of the very modest ones, up to, in all likelihood, many, many millions of dollars for the wrongful deaths, for the serious injuries, for the very large properties, those kinds of things. The point is there are going to be very, very different awards that are going to be given, and it's all going to be based on what each claim is worth. We have done estimates as to how much money it's going to take, and again, we think 13.5 is going to be enough to fully pay everyone. The problem is we, and by we I mean the trustee and the claims administrator, because this is something that all of the attorneys submit the information we have. The trustee and the claims administrator do not have information on 100% of the claims. We have information on about 70% of the claims. And that's no one's fault. It's just that as somebody who's worked on a lot of these fires, I can tell you, our clients tend to provide information at different times. Some people want to do it right away. It's therapeutic for them. They really want to get it done. But other people, understandably, are just trying to survive. They've been through, in some situations, for the extreme example, somebody lost a loved one or somebody was left homeless and destitute. They've been through either the worst thing in their lives or something close to it, and they're just not in a position to provide their attorneys, whether it's us or somebody else, with all the information they need. So as a result of that, there are about 25 to 30% of these claims where we have a general idea because we know what was listed in the proof of claim, but we don't know the specifics. And so because of that, we cannot be 100% sure that 13.5 is going to be enough. So the trustee will decide how much is going to be held back. And it may be a situation where he pays out 80% and decides to withhold that 20% until it's determined that there is enough to pay everyone 100 cents on the dollar. So to use that other example, if your claim was worth $500,000, the trustee had decided that, he would pay $400,000 and he would hold the other $100,000 in the trust until he had determined that there was sufficient money to do it. I think that's what's going to happen, but we're not 100% sure. One thing I can promise you, though, is that our attorney fees are going to be calculated on what you actually recover. So if your claim is $500, but you only get $400, it's not like we're going to get attorney fees on the $500. We're going to get the attorney fees on what you get, and then when the other money comes in, then we'll receive the balance of the contingent attorney fee. So that was another question that a lot of people had. Let's see. Another question is, do we have to complete a personal property item list, and is there a due date? The answer to that is you do not have to, but I strongly encourage you to do so because we will not be able to ensure that you get 100% of your personal property losses unless we know what you lost. So the only way that we can be sure that you get what you're entitled to is if you complete the list. That said, some people don't want to do that. And if they don't, certainly they have that right. I strongly recommend it. In terms of a due date, I just encourage people to get it done as quickly as possible because we want to submit your claims as soon as it's open. My goal is, because I know that there are going to be some delays for some attorneys and their clients, I would love to have 100% of my clients submitted the first day it opens. Now, I know that's not going to happen. I know a lot of people need additional time. People are going through all kinds of things, and I understand, but I just encourage everyone who can to get everything done now so that we can get that done and submit it as soon as possible. The other question that came up a lot is, are we looking at any delays due to COVID-19? I don't believe we are, is the short answer to that question. And the reason for that is that the bankruptcy court, unlike the California Superior Courts, the state courts right now are completely shut down. So in the other fires that I'm working on, we are unable to have any official contact with the court. We have informal contact, but we can't go in, we can't make motions, the court can't do any official business. That's not the case with bankruptcy. We have been having hearings every week, in some instances more than once a week. It's just all done telephonically now. So obviously that's not ideal. I personally prefer to be in court, but you make do with what you can, and we do not want to slow this process down. So we have done everything we need to do in terms of court hearings. It hasn't affected us. The legislature has not given any indication that they're going to extend the June 30th date, which is the drop dead date for PG&E to emerge from bankruptcy. And PG&E hasn't indicated they're going to ask. I think it would be unsuccessful, but they're certainly, they have the right to ask. It doesn't look like they're going to. It looks like everything's going to go forward. So, I say that based on the information we have now. As I'm sure everyone's seen, it looks like our efforts to flatten the curve in COVID are working. California is having less problems than some of the other states. And so obviously we're hoping that continues, and we're hoping things go well, that the economy is able to start up again next month. If it does, I think this will, at least according to what's going to happen in bankruptcy, really be a very small blip. It's not going to have a huge impact on the plan. You know, that said, if the sky falls and if we go into a catastrophic depression that lasts for a year or two, it clearly is going to have an impact. All we can do is go based upon the projections that the experts have come out with. Those look like it's not going to have an impact. But if, you know, there's a horrible contingency that happens in the next 30, 60 days, we'll have to talk again, and you know, we'll reassess at that point. So those are the questions that were the most frequently asked. And so what I'd like to do now is just open it up, and anybody who has questions, Shuey will read those, I'll answer them, and we'll stay here until everybody gets their questions answered.
Okay. One of the questions was, how do you decide what claim to handle first, and in what order, if any?
Yeah, that's a good question. And the question is that, or the answer to that is that we basically do it according to when we receive the information. So as we receive the information, we have about 50 people working on this, and they prepare the mediation, or not mediation, but the demand packets that we're going to submit. Most of them will be resolved without going to mediation. Some will have to, but that's how we do it. Now, the older a case is, you know, for example, the Butte fire that happened in 2015, those are done. So those are already ready, and they're going to be submitted immediately when it's opened. Some of the more recent cases, for example, some of the camp cases, we haven't received all the information we need in order to submit that. So that's the answer. If there are two that are equal in terms of timing, if one is what we call a preference case, meaning that you're 70 years of age or older and in very poor health, then we always try to push those forward for obvious reasons. We want to make sure those people are compensated. But typically, it's just as soon as we get them, we submit them.
Okay. And another question is, will the payout factor in how much insurance has already paid?
Yeah, that's another good question. So the question is, when insurance pays you a certain amount of money, is that deducted? And the answer is yes. The goal here is to make people 100% whole, but not to double recover. And so if, for example, your losses were $2 million, but you received $1.2 million in insurance, then that would be deducted and you would receive $800,000.
Okay. And another one of the questions is, how is emotional distress damage going to be factored in? Somebody here asked, such as the loss of a pet.
Sure. A loss of a pet is something that you can recover for, and it varies. There are some people who are extraordinarily close to pets. And so what we do is we create a narrative and we describe what that's like, what their loss is like. Let's say you had a service animal that had been by your side for, you know, several years, and you relied on them and you lost them in the fire. That can obviously be devastating. On the other hand, if you had an animal that lived outdoors that you that you saw and you certainly cared for, but you didn't have a particularly close relationship, that's going to be a little bit different. It just depends on the circumstances. And so the goal here is to create a narrative that has all the facts, and then we give those to the trustee and the claims administrator, and then they make a decision as to what they think a fair amount is based upon other similarly situated cases. So you're looking at prior verdicts, prior settlements, arbitration awards, that kind of thing.
Okay, another question from a few people has been, how are we going to vote, and when is the deadline to vote?
Okay. Well, that's what we're here for. We're here to advise you on how to vote. How everyone votes is up to you. We recommend voting to accept the plan. And again, the reason for that is the only alternative that's been put forth is the contingency plan. There is talk about a COU. I know that people have talked about that, a consumer-owned utility. The problem with that is that there would have to be an entity that was willing to come in and buy PG&E. For example, the state of California thought about doing it. There was a bill that was introduced in the legislature in January. Governor Newsom toyed with the idea, and they decided they didn't want to do it. I understand why they made that decision, and you know, certainly you can debate the merits, whether it would be better to have a municipal-owned PG&E or whether it's better to have a private-owned. But the bottom line is the state decided not to do it, and while Mayor Liccardo of San Jose and a number of other mayors put forth a letter saying that they would like to see it converted to a consumer-owned utility, the problem is that unless PG&E either voluntarily agreed to do that, or the municipalities or the state came in and put up the roughly $59 billion that it would take to fund this plan and emerge, it just couldn't happen. And so the state was the one that had the money. They decided not to do it. The consumer-owned utility did not have the money, and PG&E did not agree to the voluntary conversion. So that's not going to happen. It's a long way of saying, if this plan does not work, then unless the judge decides to disregard the vote and just order it anyway, which he's indicated he's not going to do, but he could change his mind, he has that right, then what will happen is PG&E will have what's in effect a trustee. It's called a transition officer appointed. That individual will sell off all the assets however he or she can, whether it's individually, whether it's selling part to one city, part to another, however the most efficient way to do it is. But everybody anticipates that would take years, probably somewhere between 2 and 4, and is not going to yield the same amount of money. It's probably going to be significantly less. So our best estimate is that if that happened 3 or 4 years from now, you would be receiving a check for less than you're going to receive if this goes through. Based on that, we think that this is a deal that should be approved. We think it's in our client's best interest. So we're recommending that you support it. But again, ultimately, it's up to you. In terms of the deadline to vote is May 15th. Remember, though, if you vote by mail, your ballot must be received by May 15th. So if you're going to vote by mail, given all of the issues that are happening, particularly now with COVID-19, I would recommend postmarking it no later than May 5th. Give it 10 days to make sure. And prime clerk and the bankruptcy court are asking people if they can to vote online because it makes it a lot easier for them. If you'd like to do that, it's simply a matter of logging into prime clerk. Each of you will receive an individual e-ballot number. You put that in, it pops up, and you vote accept or reject. If you have any questions about that, we're happy to help you. We're happy to walk you through it.
Another question we have here is there a time frame when you expect people to be receiving their settlements?
Yes, in terms of the time frame for receiving settlements, I believe we're going to start seeing payouts hopefully in September. I mean, that's obviously optimistic, but certainly the latter half of this year. If it funds August 29th, as the RSA says it has to, I think we're looking at payments for the first claims in September, October, and then it will go from there.
And I have another question regarding attorney fees and how those are deducted from the settlements.
Sure. The way that it works is that because of the inverse condemnation, cause of action, you're entitled to be compensated for your attorney fees and your expert costs for your economic damages. So the way that we calculate it is we figure out the economic damages, we put your attorney fees and costs on top of that, and then we put the non-economic damages on top of that. So PG&E ends up paying the majority of your attorney fees, all attorney fees for economic damages. And then the way that it works is everything is added up, comes to a number. When that number is awarded by the trustee or the claims administrator, then we receive our percentage and our costs out of that. But again, we don't get paid until you receive the settlement, and that's how we receive our money.
We have another question from a few of the Butte clients, and they want to know their claims that says, Mr. Singleton came up with an amount for my claim before the bankruptcy. How, if anything, does that change my claim now with the bankruptcy?
Right. The answer to that is it depends. The trustee is deciding now whether or not to pay interest on the claims. And we are certainly asking that he does. Obviously, if he does end up paying interest, then that will be significant for Butte claimants because theirs is going to be 5 years. So anyway, we'll have to wait and see. It's Justice Trotter's decision. He will make that decision. If he does pay interest, then we will increase the amount by the amount of the interest. Otherwise, what we're going to do is break it down into two different categories. There's a group of 52 individuals who settled with PG&E and had signed settlement agreements prior to the bankruptcy. They just didn't get funded. For those cases, the trustee has already agreed to accept that amount and to pay that amount. So those will just be submitted. That claim will be finalized and they'll be paid. For the other ones, we've come up with a demand amount. And so we will either add the amount of the interest to that, or if interest is not going to be awarded, then we'll submit that initial amount and we'll go forward and try to resolve the claim that way.
And another question from a few of the clients has been, are the settlements going to be taxable?
So the question of whether or not settlements is taxable is complicated, and it depends on the facts of the individual case. The general rule is that if you receive money for economic damages, and if you haven't taken any type of capital loss, but if your home burned down and you're paid $1 million and you put that $1 million into rebuilding it, and again, you haven't taken a capital loss, then there hasn't been a taxable event. Now, again, that gets very complicated as tax law is. And so our rule is we can tell our clients the general rule, which is what I've just described, but for any specific case, you should talk with a qualified either CPA or tax lawyer who specializes in this, and we're happy to refer you to people that do that. But again, it really depends upon the facts of the individual case, what is the claim based upon. For example, a claim for lost wages, you are going to have to pay taxes on that. A claim for real property damage, if you haven't taken a capital loss, you usually won't. But those are things that have to be determined on a case-by-case basis.
And another question from, again, a few of our clients is, what is the soonest we will be able to submit demands for settlements?
It will probably be in July or August. The answer to that is as soon as the trustee and the claims administrators have completed the entire process and asked us to submit, we'll begin submitting. I mean, we have literally hundreds that could be submitted right away if those were opened up. And by the time we get to July and August, we'll have thousands that are ready. The problem is it's dependent upon the trustee and the claims administrators. And one of the things that we've been working on is making sure that they have the funding they need so that they can build up that process, because it's going to be expensive and they need that money. Again, it looks like that deal has been reached, and so they will have the funding, so they'll be ready to go. But as soon as they tell us to submit, we'll be ready to submit.
Okay. Let me see. I'm gonna try to open it up for unmuting some of these clients that have their hand up.
Sure. Please, yeah.
Give me 1 sec.
I have a question. Can you please address whether COVID-19 event will slow down the current date for this case?
Erica asked the question, and this came in through the video chat. Will COVID-19 slow down the dates? Again, I don't think it will. We're going forward and we're having all of our hearings telephonically in bankruptcy court. And in terms of the June 30th date, the legislature has indicated it's not going to extend it based upon what it knows now, and PG&E is not planning to ask. So at this point in time, we don't believe that COVID is going to delay the bankruptcy. That said, if there is a major setback, if we have, an incredible increase in the number of infections, that could change. But as of right now, certainly knock on wood, we don't think it's going to.
Anybody with their hand up?
Looks like there's one right there.
Will compensation from PG&E be reduced if you receive insurance compensation?
Yes, the question was, is the amount you receive from your insurance deducted? Generally it is. There are times when there's an agreement with the insurance company and the individual based upon bad faith conduct by the insurance company that the insurance company can't subrogate. If that happens, then it's not, but the vast majority of the time it is. I think there was a question, I believe it was Larry Olson. Yeah.
Mr. Olson, I've unmuted you. Go ahead and ask your question.
Thank you. Thanks very much for going through the calculations for the trust fund valuation. However, there's a lot of complicated, calculations there. It'd be helpful if you would write up with an example of the valuations and how it's calculated with defining the terms. For instance, yearly earnings is one of the major factors in that formula. So that would be yearly based on what period? Would that be over the past year as of August 29th, year to date? Would it be based on the quarterly figure or what? So that would be helpful.
Yeah, no, and that's a good question. I believe it's going to be based on anticipated yearly earnings of 2021, based upon the projections that are going to be submitted later this year. That said, what I'm going to do is go back through and check specifically, and we'll put this in the update letter that's going to go out next week, because we're going to send out weekly update letters. If that isn't sufficient, then please let me know, and we can talk more about it at the town hall next week, or you're welcome to call me at any time.
Okay, thanks.
I have Wyatt Howell.
I just have a quick question. You covered most of it, but my question is specifically, where do we vote?
Okay, yeah, that's a good question, the logistics. So there are two options. You're going to receive a ballot either in the mail or electronically. Once you receive that ballot, you have two choices. You can print it up and fill it out, including signing it, putting in the last 4 digits of your social, all of that, and then you mail it to the address that's listed on the ballot. That has to be received by May 15th. And again, it has to be received, not postmarked. So I strongly recommend, if you're going to vote by mail, that you postmark it no later than May 5th. The other alternative is to go to the Prime Clerk website, put in the e-ballot number that you will receive, and vote that way. If you do that, you just check accept or reject. And if you have any questions on how to do that, we're happy to walk you through it. That is the way that Prime Clerk and the Bankruptcy Court have asked people to vote if they can, because it makes it easier for them to tally the votes. That said, if you do not wish to vote that way, you absolutely have the right to vote by mail. I just, again, want to caution everybody to remember that it's received, not postmarked by May 15th.
Okay.
I like will the new fires affect our current cases? And I think they're referring to Kincaid.
Okay, good.
Can you repeat the question?
Sure. So one of the questions that just came up on the group chat is, will the new fires, and by that, I believe they're referring to Kincaid and Lafayette that occurred last fall, affect these settlements? And the answer is no. All of the other fires, and that's the 2016 Ghost Ship fire, that was the tragedy that killed 36 people in downtown Oakland. That fire and the post-petition fires, meaning the fires that occurred after PG&E filed for bankruptcy on January 29th of 2019, which would be the Kincaid fire and the Lafayette fire in Sonoma and Napa counties, are not going to be part of this. So they are completely separate for their purposes, for the purposes of those three fires. It's like the bankruptcy never happened. They can bring their cases in Superior Court and they will be paid by the insurance. So if the Ghost Ship plaintiffs are able to prove liability, then they'll be paid by that insurance policy, which is for the year 2016 and is completely separate. For Kincaid and Lafayette, liability is different. Certainly in terms of Kincaid, it's very clear. And so they will be paid by the insurance. And if for some reason the insurance is not sufficient, then they can access the AB 1054 fund and they'll be paid that way. So it will not in any way affect any of you. Nobody has to worry about it diluting what's available in the $13.5 billion trust.
Okay, I have somebody on the phone that I'm gonna mute. They don't have I don't have their name.
Okay.
But it's somebody with phone number ends in 6500. Go ahead.
Hello.
Yes.
Hello, Mr. Singleton.
Yes.
This weather. When do we get that ballot?
Okay, so the question is, when do you get the ballot? If you have not received it by tomorrow, which you should, please let us know. Erica Vasquez is our partner who handles that. She's in charge. And so she will be following up. We're going to follow up on Monday. So anybody who didn't is going to get a reminder. If you didn't receive the ballot, please let us know, because we want to give you the ballot and most specifically your e-ballot number, so that if you want to vote online, you can just log in and do it.
There's no personalized information on the ballot itself. All they need is their e-ballot number. And
Okay.
they will receive that from us by the end of the day tomorrow,
Okay.
if not already.
All right. So again, that was Erica, and she said if you haven't received your e-ballot number yet, you should receive it by the end of the day tomorrow. If you don't, please let us know so we can get that to you, because we want to make sure you have the opportunity to vote.
And another question that was just submitted is, what if there's fires this summer? Will
Right.
this affect these claims?
So the question is a very good one. What happens if there are fires this summer? Obviously, everybody's hoping that doesn't happen. I think the people in Northern California have been through enough, so we certainly hope that doesn't happen. However, if it does, it will not have any impact on this deal. The reason for that, again, is AB 1054. What will happen is that as long as PG&E gets out of bankruptcy by June 30, then PG&E's insurance will cover it. And again, that's usually up to $1 billion. It can be a little less or a little more depending upon the circumstances. If that is not enough to pay the damages, then PG&E can access the $21 billion AB 1054 fund, and the victims of that new fire will be paid out of that. So that's the reason, again, why we think this stock is going to go up, because unlike in the past, where PG&E had to pay everything that was over and above insurance out of its own earnings and assets, or borrow the money, now they can access this AB 1054 wildfire fund. They can pay everything out of that, which makes it much more attractive for Wall Street and investors.
Okay, and another one of these questions, we have clients that have claims in Butte and then also in other fires like Redwood. Do they get separate votes?
Yes. So the question is, let's say you have, the example was a client who has a loss in the Butte fire and the Redwood fire. But it can also apply if you had two different addresses and submitted separate proof of claims for them. For example, if you had a primary home and then you had a property that you rented out, something like that. You get a vote for each proof of claim that you submitted. So if you had two different properties and you submitted different proofs of claim, which is generally how we did it, generally we did a different proof of claim for each property, then you would be entitled to two votes because you have the two different properties.
Thank you. Also, if you have a question you want me to unmute you, please use the raise your hand function. It should be at the bottom of your screen, and I will do my best to unmute all of those who have questions. I do have a few questions about SSDI benefits and how these settlements would affect those benefits.
Sure. Those depend on the specifics of the type of benefits you receive. And this was a question that came up a lot in the Butte fire. And so what we did was worked with a specialist in this area who was able to advise our clients about this. And we're happy to refer anybody who has questions to that specialist, or you're certainly welcome to consult with a specialist in your area. But the simple answer is certain types are not dependent upon income or assets, and certain types are. So if you are receiving the type that is, then you may be ineligible, or sometimes you can structure your settlement, meaning you get a certain amount every month, and that way you would still be able to, for example, if you're on Medi-Cal, something like that, you can still have it, health insurance, while you receive a certain amount per month.
And I am about to unmute Mr. Martin Shaler. I believe he has a question.
Sure.
One second.
Actually, I just wanted to say, first of all, that I vote yes on this plan. And as far as forward-looking PE ratios for PG&E, it's about 4.04. Now, that being said, I'm an investor myself. I'm a stock trader. It is a buy. Okay, so for those who are on the fence about that idea, I know you're saying that you have it locked in at 14. Typically, this sector runs about a 28 PE. And I would say that, guys, this is the best deal we could possibly get. I'm totally 100% for this. The only thing I would say is that I noticed in reading that you guys are looking at selling it over 6 months to a year. I really think that you should probably wait it out a little longer. I don't necessarily think that you're going to get what you need in that time frame. Hopefully you have experts that are talking to you about that, but I'm hoping all the claimants here are willing to wait that time, understanding that maybe they get 80% of their claim and wait it out. I'm just saying 6 months to a year is not long enough to wait for those PEs to go back in line.
Well, I appreciate the comment. And here's what's important to remember about that. We can certainly tell the trustee what we think, and the trustee obviously has a fiduciary duty to all of the victims, but ultimately it's a decision that the trustee is going to make with his financial advisor. As it's been explained to me, there is something called the prudent investor rule, which requires that you not keep too much of your funds in a single asset. So I believe what's going to happen is as soon as that stock is funded, a portion of it is going to be put into very conservative assets, whether that's T-bonds or whatever it is, something that pays a very low amount, but which we know will not go down. And then there will be another portion of it where they do exactly what you said. They're going to try to ride it up. because any of that increase is going to go into the trust and is going to increase the amount of money available. So that's what we're going to try and do, and that's what the trustee and his financial advisor are going to do. Obviously, I agree with you. I think that this is going to be a good deal for everyone, and the stock is going to be worth more than the 6.75. So we'll see. And again, thank you for your comment.
All right, I have a question from Ms. Susan Thomas.
Okay.
Oh,
Okay, unmute.
okay, hold on. Hi, can you hear me?
Yes.
Oh, great. We're wondering, when will we know the final amounts of our individual claims that will be presented?
I think that will be probably in, depending upon your case, but I think it'll probably be July or August. The best thing to do is just to contact us offline, and we can look and see if we've received all the expert reports we need for your specific property. If we have, then it won't take us too long to get that finalized. On the other hand, if we're waiting for one of them, then that may take some time.
I don't have anybody else.
I think Mr. Brazil in the corner there.
Yeah, let me get Mr. Brazil 1 second. Go ahead, Mr. Brazil. Mr. Brazil?
It says mute.
No, you're unmuted. I think you have, can you check the bottom left-hand corner of your screen? I believe you have your mic turned down. We're unable to hear you. Let me see if you typed in a question. And again, we have, I am saving all of the questions submitted by each and every one of you. If we do not get to it, I will make sure we get these answered for everybody.
Do you mind trying Mr. Brazil again, just to make sure? I think it may be a faulty connection, but just to see if we can get him.
Yeah. 1 second, Mr.
He is asking you to please address withholding taxes. So he's typed in his question to you. I think he.
I see. Okay. Mr. Brazil, it looks like you just typed it in and you said, will you please address withholding taxes? Okay. So again, we are not tax experts, and I want to make sure that's clear. There will be no taxes that will be withheld from the settlement. The way the settlement agreement works is that the recipient agrees that there's no duty to withhold and that they will pay all of the taxes. Then in terms of whether or not there are any taxes on your specific claim, that will depend upon the circumstances. So again, generally speaking, if you receive money for compensation for damage to real or personal property and you replace that property, there's not been a taxable event, so there's no taxes. Now, there are other circumstances. If, for example, you had lost wages, or if you took a capital loss, any of those things can change the calculation. So what I would recommend is that you consult with a CPA or tax attorney who specializes in this area, and we can certainly give you the names of some that do, who we refer clients to, if you'd like.
And I have a question. I'm about to unmute Taran Finley.
Okay.
Go ahead.
Hi, that's Taryn.
Taryn, my
Thank
apologies.
you. Hi. So my question probably doesn't pertain to anything anybody else has said, and I appreciate all the information that has been given, particularly to myself, because I was hospitalized 3 different times. I now carry, well, I don't carry it with me, but I have an EpiPen. I'm constantly on steroids. how can someone get in contact with me so it doesn't take up all this time in this meeting so that we could try to work out? Mine seems to be really different from everybody else, is what I'm trying to say.
Yeah, no, and I'm very sorry you're going through that, but you're 100% right. For your specific case, we're going to need to get all of your medical records, and then we're going to need to have an expert look at it and give us an opinion. So I think that would be great. If you wouldn't mind just contacting the office tomorrow, we can get that process started.
Okay, I appreciate all the information. Everybody just stay safe and hunker down.
Absolutely. And again, I'm sorry for what you're going through.
Thank you.
All right, I have a question. I don't have the name of the person there on the phone, it looks like, from a Galaxy phone. I'm about to unmute them.
Okay.
Go ahead.
Yes. My question is, when will we find out if it passes as far as the vote?
We'll know whether or not it passes numerically shortly after May 15th. They'll probably put that out within a few days because they'll have to check the mail-in ballots. So we should know in advance of the hearing, but there's a hearing on May 27th, and that's when the judge will make his ultimate decision. Now, technically, even if it passes, the judge could decline to approve it. Nobody believes there's any chance of that happening, but we won't know for sure whether it's approved or not until May 27th. However, we should know a few days before, and as soon as we hear what the results of the vote are, whether or not we got the 67%, we will let everyone know.
Great. Thank you. Thank you for all your time.
Absolutely.
All right, I have another person on the phone. Phone number ending in 6500. Go ahead.
Hello, Terry, that's a Singleton.
Yes,
Can you hear me?
I can.
Can you hear me?
Yes.
Okay. About the personal property, that I got a list from the office, but what's the deadline on that to send it in?
Okay, so
The personal property.
yes. The question was, what is the deadline for personal property? There's no deadline, but obviously the sooner the better, because we want to get everyone's claim submitted as quickly as we can. So once we get that, then that's another step towards getting your claim submitted. Obviously, if we don't get one, then that will delay it.
And I have somebody submitted a question about the, it says, I heard we need 2/3 to pass. And if you don't vote equals a no vote. Is this true?
Actually, no. Not voting simply means that you don't vote. It's 2/3 of everyone who votes. So if there's 77,000 total victims, if only 30,000 voted, then you'd need 20,000 plus one is all you would need. You just need 2/3 of the number of people who vote.
And another question here is, do you know of any large groups of fire victims or attorneys who are opposing this settlement plan?
We do not. I speak regularly with the other members of the consenting fire claimants professionals, and that's the group of us that represent over 70% of the individuals, as well as the TCC's attorneys. And I do not know of anyone that is opposing it. We have the second largest group. We have 7,000, but the people with the largest group, they have 18,000. And then there's a couple that have 6,500, 5,000, 4,000. We were all on a call earlier today, and the responses have been uniform. I mean, everybody is saying that it's over 95% in terms of what their clients are telling them. There certainly are some people that are opposing it, but I don't know of any groups that are opposing it. And the TCC, just to be clear, is not opposing it. They were just saying they wanted people to wait until May 1st. We don't think that makes sense, which is why we're not saying to do it. But I don't know of any group of attorneys that have more than 50 to 100. maybe 200 that are opposing it.
And a few more questions here about, so what is a recommendation that you're making to our clients about the vote?
The recommendation is to accept and to vote to approve the deal. Obviously, there's no rush. You don't have to do it today. My general sense is that once you've made up your mind, I always recommend just doing it and getting it out of the way. But again, there's no rush. You have until May 15th if you vote electronically. And if you vote by mail, again, please get that ballot postmarked by May 5th. But again, there's no rush. Take your time. Once you've made up your mind, if you need any assistance, let us know. But again, we do recommend that you vote to approve. Do we have any other questions either on chat or is anyone interested? And again, we will do this next Thursday. We're going to be doing this until the voting is done, just to make sure that everybody gets their questions answered. You can always call or email us. We'll send out an update letter on Monday that has additional information. And again, if you haven't received your e-ballot number, please let us know. We will get that to you. Any other questions before we sign off? Okay, well, thank you, everyone. I know this has been very long. Looks like we're getting toward the end of it. So everybody, please stay safe, and I'll talk to everyone next Thursday. Take care.